Mediator is a facilitator of communication, but they're not actually imposing any decisions on people. They're really helping people come to their own agreements. The difference with a conciliation in a court setting, the registrar is helping these people come to their own agreements, but it's being very directive about what the agreement should be, and will also talk about what might happen if the case goes to court. So they might say, well, if this case went to court, I think you'd get between 50 and 60%, so you should settle for that.
So is it like an advisory mediation?
Yes, yeah.
Is that what the conciliation is?
Yeah, it's like an advisory mediation, but you've got this registrar who's attached to the court, and they've also got a lot of a sort of authority power, formal, because they've got that authority of the court. And also, I'm not sure if you've heard, but in the courts there are dreadful waiting lists to get hearings. So say at the court the other day, they were saying, and this was for children's cases, it might be worse for property, there are no hearings until at least March, April next year. So that means if you have a case in court now, you won't get a hearing for, and that's not a year, is it, but 3/4 of a year. So that's the other thing that the registrar will be saying.
So why would they go to conciliation court?
Why would they go? Because they've got financial issues or financial and children. They haven't been able to work it out so far. So they've been through all these court stages. Can anyone think of what might be some reasons why they can't work it out?
They want a decision quicker than 3/4 of a year.
Well, if they want a decision quicker, they have to work it out, don't they?
I would say that it would be around asset division.
Yes, they can't agree.
They can't agree on who gets what.
So they can't agree, and often it's about percentages, like I want 70%, no, I'll only give you 50%. What other, can anyone think of anything else that might happen, say in property, that might mean they can't agree? And one of the most common things is people, for example, not making full disclosure, not wanting to...
where one is a high-powered earner, the other one doesn't work, or there's an inequality in...
Yeah, they might have differences of opinion in what the settlement should be. They might have differences of opinion in what their contributions were. Also, a common thing is that one person won't make full disclosure. So the property ones, before you have, say for example, a property mediation, in theory you should have full disclosure of everything, particularly of all of your assets, your liabilities, your superannuation entitlements, all that sort of stuff.
Does the court have the ability to find out that information if one party is saying, oh no, I don't have a bank account, the other with $100,000?
They do to a certain extent, but say if I'm a lawyer acting for a wife and she thinks her husband's hiding stuff and she hasn't really kept good track of stuff during their marriage, I need the client to be able to give me an idea of where stuff is so I can subpoena the information. If we don't know where stuff is, we may not be able to, subpoena it, find it, prove it.
So it's up to the party to prove that there is money hiding.
Yes, yeah, like say if, we've got lots of property and the husband squirreled it away in some, exotic location, but the wife doesn't know where it is or she doesn't know that's happened, you may never find it.
Can I ask, if a decision's been made and then it comes to be known a few years or a year down the track that there was not full disclosure, can there then be grounds for it to be referred again?
If it was a contested hearing, I would think not. If it's an agreement, if you enter into an agreement, you can reopen that if there was fraud. So if you entered into an agreement and you find out that people weren't being honest, you could. to the parties because of our, we call it an adversarial system. It's up to the parties to make their case to the court.
That's what it is.
So it's not a perfect system. The court will order the conciliation. So say if you've got a property case, and same with the children case, you'll sort of have from the time you file to the time you might possibly have a court hearing, you'll have different steps. So you'll have some steps. You might have a court mention. You might have your conference date. That's your conciliation conference. Then you might have your what's called a directions hearing. So when you get up to your mentions here, the court might make orders for certain things to happen and for the conciliation conference. And normally there are orders for, if people haven't made full disclosure, the court can make orders for that. And even if you get up to this stage and someone hasn't made full disclosure, the registrar can make orders. So that's the difference too between a private mediation and conciliation. The registrar has power to make orders. But something I learnt by being a lawyer is not everyone really cares about court orders and not everyone complies with them. So, you know, generally people do, but when you go to court you do see a proportion of people that don't, and that's why they're in court.
So what's the consequence if you're told to by the registrar or the judge to give full disclosure and you don't?
Well, I guess they can just keep asking you to give full disclosure and keep ramping up the orders that they might make against you. They can too, you know, if, say for example, the wife's saying that you've got money and you won't make disclosure about this money, the judge at the trial can make findings sort of adverse to you. So they'll say, well, you haven't been prepared to give us any of this information, so I can find that the wife's saying the right thing. So they can get findings made against them. Just like with paternity testing, if someone refuses to take a paternity test, the judge can say, well, I can now make a finding that that's an option, that you're the father, because you won't take the test. Okay, so
Sorry, no, just on
yeah.
that. Just so in that little matrix that you've gone there, so conciliation conference, then that can be the end. It won't go
Yes.
to hearing or court hearing, so the conciliation they can say, yeah, shake hands, walk out.
And I should say too, before you file in court, you are supposed to try and settle it here.
Yeah, that's your mediate.
So in property, it's not compulsory to mediate, but a lot of people now would or they should negotiate. They're supposed to have done something before they file. You know, when they go to their mention, the court will be saying, what have you done to try and settle? When they go here, it's a chance to settle. Even between here and here, there are chances to settle. The director's hearing is, you haven't settled it, now we're going to set it down for hearing. You could still settle it at any time. And of the amount filed, only a tiny proportion end up in a court hearing.
But often by the time you go from mediation to property, from mediation to the court hearing, the money you've used to spend on that whole process, the 50, 60%, 10%, you know, that you fought over is actually gone.
Yeah.
Yes.
You know, like they reduce their.
Yeah, well, to make it worth going here, you have to have quite a lot of property.
Yeah.
Because so friends of mine have just been in a dispute about property, and the husband had spent $50,000 on lawyers and hadn't even got to a mediation.
Wow.
So he had filed because he felt that he couldn't work anything out. They didn't get here. They probably got to a mention, and then they organised their own private mediation, but it kept getting adjourned. He had spent way over $50,000 to get up to here. Now he did have quite expensive lawyers, but it's a lot of money.
Can I ask two questions?
Mm.
The first one is, can the judge court order mediation?
Yes, they
And so
can.
is that before conciliation or is that conciliation? So if they haven't tried to mediate before they file, when they don't have to, when children are
It can be actually either. Generally the court, at the moment, the family courts like to order mediation when both people consent. So if both people consent, they can order a mediation at any time. They also now, particularly in the Federal Circuit Court, because conciliation costs money because the registrar's an in-house person, they're trying to get people not to go to conciliation but to pay their own mediation instead.
Yeah.
So you can actually have a mediation instead of that, or you can have a mediation at any time or beforehand.
And so say your friend spent $50,000
Yes,
on the mediation,
my poor friend.
for the mediation.
Yes.
Would that then come out of the total property pool or not? So it's
He'd have-
costing
she'd have to
parties.
Theoretically, it
money
should
as
have come
well.
out of the pool because it's his fund, it's his money,
So
you know?
it's his, so the legal fees of both parties don't come out of the pool at the end, like, so.
Not
No.
really.
No, they don't. They have to go.
No.
Sorry, I've been through this.
Ah!
And I'm looking at it going, I wish I'd settled there.
Yeah.
No, generally they don't because that's your own expense.
Wow.
Yeah.
So if one gets legal aid and one doesn't get legal aid, then one's already disadvantaged.
There's
Yes.
not a lot of legal aid for property.
No,
So generally, nearly all the legal aid conferences are children.
Or were children legal aid?
Even if you get legal aid for property, it's normally, you'll get a legal aid conference.
Oh, that's crazy.
They generally wouldn't fund legal aid clients to a property hearing anymore. They did in the olden days, but they would make them usually pay it back. So you generally, even if you do get legal aid for property, you'll only get it for a mediation conference. Yeah, so I guess that's one of the main incentives for mediation, isn't it? It's about time, cost, stress, because if it takes 2 years, generally it takes 2 years to get here.
So when you say the court hearing, so when you say that there's
Sorry.
3/4 of a year to get into, from application, does that mean to get to the mention?
The one I was talking about where it was 3/4 of a year, it was children's cases and they're at the direction hearing, and it was 3/4 of a year for that bit. So they're in the family court for their directions hearing to get set down for hearing. So they're there last week and they can't get a hearing until March, April, but they're at this stage.
So all of the stuff before that
Has
obviously
already.
takes longer time.
So we've obviously discussed litigation. Now arbitration hasn't taken off that well in family law in Australia. It is an alternative to this court hearing. It could happen at any stage, so the benefit is it can happen a lot earlier than 2 years, but it's a private process. You have to pay for it, and it's not binding till you file what's called the award. So an arbitration would be, say if I get you people, Sandra and Kate, and I'm going to be your arbitrator. You would decide what sort of process you want, whether you just want to file documents and get me to read them, or whether you want a little mini mock hearing where you give evidence and get into a witness box.
Yeah.
I'd set the amount that you pay me, so we could have it a lot quicker, and we'd have to do all the disclosures, so we'd have to make sure they'll make full disclosure and give us all their documents. So it's a lot cheaper, quicker, provided they'll make full disclosure. But then at the end, when I make my decision, I give it to them, and they have to go and file it in the court for it to be binding. So that's one sort of downside.
Donna, can I ask, would clients get told this this whole process? Because wouldn't it be in the lawyer's best interest to take them to the court hearing because they're earning more money? Are they ethically?
You're a smart cookie.
Are they ethically bound to say like the average client and average cost? Because
They are ethically
for them
bound.
it's just to stretch it out as long as they can.
Lawyers Lawyers are ethically bound to give clients advice about alternatives to court. Family lawyers are ethically bound to give all of that information. And then in practice, it just really depends on the lawyers.
They don't have to support them, like
Uh,
push it if they don't want. They just have to give the information.
If you go to a good family lawyer, they'll be trying to settle your case. But there are, you know, in a profession, there are a range of people.
Yeah.
There are lots of lawyers out there.
Yeah.
If you go to a really good lawyer that knows what they're doing, they will try and settle your case, and it's their job to try and settle here. If you're a good lawyer, that's what you're trying to do, because you want to keep your clients' costs down, you want to keep stress down, particularly if they've got children. Going all through this is going to escalate conflict in your family and make your children worse off.
Well, they would love the other party that doesn't want to settle, the lawyer.
But lawyers also get a name for being ones that settle quickly, have your best
Okay,
interests at heart, you know, and lawyers that drag it out and try and get your money, get
But
a
I don't know if
name.
it's just only the lawyers, because if you've got the other party who doesn't
That's
want to
right.
settle.
Yeah.
Yeah, well, I have to say, having been a family lawyer in the past, it's sometimes easier said than done to get people
I
to
agree.
settle.
Yeah.
And even for you, it's not just the other side, it can be your client who doesn't want to settle. So lawyers have to act on their client's instructions. So you can also talk to your client and say, look, you're not realistic in what you're wanting for your property settlement. But at the end of the day, they have to decide whether they'll follow your advice. If you really feel that they're out of whack with them, you have to withdraw from their case. Now, lawyers too have budgets, so if you're a lawyer in a private law firm, you have a budget to meet every month. And when I was a lawyer, you used to have to go in for what was called counselling every month to talk to your partners about your budget and whether you'd met your budget. So there was a lot of pressure, but there's a whole lot of lawyers that are doing a good job and wanting to settle cases, and then there are more smaller proportion, and there are some really bad lawyers out there.
I have a friend who's a family lawyer, and she says, I've never won a case. She says, because there are no winners.
So who's your friend?
Shelley Kingswell?
All right,
Yeah.
Kingswell. Yeah, well, it is certainly the case when you're a lawyer in family law that you don't often have happy clients.
Yeah.
And also some of them get back together. I
I
know that sounds terrible, but I once had a client who used to ring us every day because her husband took the daughter and then disappeared around Australia with the daughter, and every day she used to ring us crying and upset and not knowing where he was, and we had to get orders from the court to trace where he was getting money out, to try and locate him. And then, you know, months and months and probably over a year later, we finally found them. And then she got back together with him. And when that happens, it's quite traumatic for the lawyer. So actually, family lawyers have also got obligations to encourage people to try and reconcile,
Really?
if at all possible.
Wow.
And we have to give them information about where they can get help for all of that.
But I'm assuming that would be obviously where appropriate, obviously if there's DV and stuff, they wouldn't.
Yes, and also a lot of the times when you see people at mediation, you wouldn't be talking to them about reconciliation. For example, they've been separated for 5 years.
Yeah.
The one I had this week, they've both had multiple partners since they've broken up. They've both had multiple children with multiple partners since they broke up. You wouldn't be talking to them about reconciliation. I think the mother would have probably strangled me.
But it often happens, I mean, if people come in not long after a separation,
Yes.
they might only be separated 6, you know, a short period of time and they come in and they're a bit ambivalent and it's sitting there in the room,
Yes.
then I think it's often appropriate then.
Yes. And it can also be, there is a sort of set brochure. I think your service has your own brochure. Then the family courts have their own sort of version of it. But the information just isn't about how to get back together. It's about where to get help for general counselling and support. So it's probably just the brochures are relevant in any case, but not the actual. You need to.
And often in the intake, that's where that can come up. Where
Yes.
you've got that ambivalence from both people, so you might not proceed to mediation because in the intake, so you might refer them out to do some sort of counselling or process there.
And actually something that happens sometimes in mediation too is that one person wants to reconcile and the other person doesn't. And sometimes if the other person will agree, you can spend a bit of time at the beginning of mediation talking about that, because sometimes they need to sort of resolve that. Not that it's resolved themselves, but they may need to deal with it before they're ready to move on to the next stage. So we've talked about counselling. We talked a little bit about family consultants. We said they work in family courts. There are also private people that work outside of family courts. Probably the main thing they do are what are called family reports. Have people heard of family reports? And there is a shorter version which people call a Section 10F report.
Is that a standard report? Like, is there a standard outline to that? You know how you have like an affidavit form, something like that? Is there a standard?
There's a standard in terms of what the report will cover, because the report always covers, for example, who they met with, how long for, when it's filed in court, it has to have the family consultant's qualifications and experience. It then will have a history, what the issues are, then it'll have a report about the meeting with each, say mum, dad, children, any significant other people, and it will also have conclusions, and it might also have recommendations of what orders the family consultant might think may be appropriate.
Do the family reports copies get given to both parties, or is it just to the judge? Because
They always get given to both parties.
if they're interviewing children, then that sometimes be difficult, because if the child says to the psychologist, "I want to live with mum."
Well, that's one of the functions. One of the functions of a family report is for the family consultant. The main way in Australia that children's views are put before the court is via a family report. So one of the functions of a family report, if children are wanting to put forward views, is to report about that, but also put them in context. So the family report writer will also talk about the context in which those views are expressed, if they are expressed. And it can be difficult for parents in those sorts of circumstances. So that's why sometimes children don't want to express views too, because they don't want to get into trouble, or and they can be influenced by parents, the one they're living with most of the time. So
One that makes them then they don't say this.
yeah, well, some parents
Well, they do.
do that. So it depends on the judge too and the report. Generally reports are quite important to courts, but I guess family report writers often spend quite limited time with their families. Many years ago they used to spend a lot more time, and they would always go out to the house for each parent. And there's been sort of funding cutbacks and also sort of cultural changes in how they're prepared. So something to be aware of is that if someone's written a family report, they may have only met these people once. They may have met the children months. They may have spent quite a limited amount of time with them. Some clients don't present that well in that sort of context. So it's again not a perfect process. It's an independent person, so it's very helpful to the court in that in our court system, most of what's put before the court is from the mum and the dad. So it's their perspective. And a lot of the time in court, it'll just be negative stuff about the other person. There'll just be all this negative stuff. And the judge doesn't really have, often sometimes there's somewhere in the middle too. So it is an independent report, which can be helpful, but it has to be seen in the context of the amount of time people have spent with the clients, the amount of time they've spent with the children, because depending on children, they may not feel comfortable with someone that they've met for an hour. There may be a limited amount of information they're prepared to share. And also they may feel very under pressure from a particular parent with how they, like the family report, the mediation I had this week for legal aid, there was a huge family report on the file, and in the family report, the boy hadn't wanted to talk to his dad at the meeting. So what happens is the family report writer interviews mum, interviews dad, interviews the kid who was 6, and then she observes the kid with mum and the kid with dad. In the observation, the kid with dad didn't want to see dad, was really negative about it, but her sort of observation wasn't about he shouldn't see his dad. So it is all put in the context of what's going on, and some of the families are very highly conflicted. Children are often caught between parents that they know don't like each other at all. So in this particular case, and actually mum at the mediation is quite happy for dad to see the child. It's just that they've had this terrible history. Dad's been really negative about mum. It's all very complicated as to why on that particular day he was being really negative towards his dad and saying, I don't want to see you today, Dad, and he's 6 years old.
And I guess on that note, I'm glad to see psychologists and social workers who make these reports rather than someone who's more clinical. So understanding a child has different behaviours to different things, and there's other issues than dad's not to bring on to the child. So I'm glad to see professionals that understand the holistic approach of one child's behaviour.
Yes. Yeah, well, I guess if people have worked with children, you probably know that sometimes it could take ages to get the trust of a child, or you may never get the trust of a child, so it has to be taken in that context as well. So they're certainly helpful. Often judges are very reliant on them, but as a lawyer who did have clients going off to get these reports prepared, sometimes you get the report back and you wouldn't be that happy with it because your client just doesn't present very well in a 1-hour interview. They may not be very
Maybe anxious.
They can be people too, if you're doing a lot of legal aid work, they're people that aren't very educated, they're not very articulate, they're not very, they don't know how to present themselves well. So sometimes people can be quite strategic in the way they present, so it's all very complicated. But, it certainly can be quite helpful. And actually at the mediation the other day, the family report actually helped settle the case because the family report writer had done a whole list at the end of recommendations about the time the boy should spend with his parents, and the parents actually accepted those recommendations. So it helped the case settle.
So this is probably a little bit out of the sort of scope, but so can either party's lawyer recommend an outside independent family consultant?
Yes. So a family report is ordered by the court. You have to get a court order, but you can both agree to ask the court to make an order. yes, one party can ask for the order, and people, you know, if people have got enough money, they can choose their family report writer and pay them.
Right.
Mm.
So could that be strategic as well? Like if one party's educated and well educated and the other isn't, and they feel that the report may favour them and that may sway the judge, and they have the money. Like,
Well, we both have to agree on who would write the report. So one person couldn't just go off and organise it themselves with someone that was sort of aligned with them. And it can't be someone that's been treating anyone or had any prior involvement. So it can't be someone that's been a psychologist or a person that's been treating one of the parties. It's got to be an independent person. But you know, when you work in the system, there's a whole lot of different report writers too, and some are perceived as being more favourable to men and more favourable to women, just as judges are. So, but it's certainly, you know, a very helpful tool, particularly when you're faced with a whole. Often family courts are just faced with a whole lot of allegations.
And a judge can make a recommendation that a child receives counselling or therapy, can't they?
Yes, the court can order. They can make orders against the parents and the children. They can't make orders against third parties. They can ask, for example, parents to undergo, for example, sometimes orders are made that parents go to psychiatric assessments. Parents then have to comply with the order. They can order children to counselling. Parents can agree to that too. So at a mediation, parents can agree to that sort of thing. One of the problems that comes up a lot of the time is one parent taking children off to things. Sometimes one of the problems is, say a parent might get an idea that something's happened or that there are problems and take children off to people trying to prove that there are particular problems. But if people are reasonable, they can certainly agree themselves on children getting some help and treatment. And all, if things can't be sorted out, all those people can give evidence in court. So people that have been treating children, teachers, often not very happy, but are sometimes called to court. And often teachers just have such an insight into how children are travelling. Like they see them turn up at, they see whether they turn up at school when they're with a particular parent. They see whether they come on time. They see what state they're in. Are they clean? Are they fed? Or are they hungry? Are they not clean? Are they dirty? So teachers aren't often, obvious reasons, very happy about having time out of the classroom to come to court because it's obviously time away from their class.
do they have to go if they're ordered?
Yeah, if they're subpoenaed, they have to go. Otherwise, you can get a warrant for their arrest.
So, but if they're not subpoenaed and they're just asked, they don't have to go.
No, you don't have to go if you just asked, but you can be subpoenaed. But they can be, I guess one of the difficulties with the court system is that a court date in the family court isn't necessarily the court date, because you might get to court and the judge won't have time and all this sort of stuff. So, but you can have your witnesses on standby. But say when I was a young article clerk, I worked for this partner who's now a family court judge, and she used to be very disorganised. And I remember her, you know, saying to me, "Oh, ring such and such, this teacher at blah blah school. We need her in court tomorrow." And the teacher was very unhappy, as you can imagine, if you got rung up and told you had to be in court tomorrow and the silly lawyer hasn't even given you notice. They're the sorts of jobs you get when you're a junior lawyer. Okay, so we've looked at some of those different processes and the differences between them, and also how much time and cost it can take for people to go to court. And I guess the main thing I think about going to court too is how it escalates conflict. Because, say this mediation I had this week, the people had been in court for years and years, mainly because of the father, I think. The father had all these issues and just kept taking things back to court. But miraculously, and maybe the family report writer had worked some magic on these people, but sometimes people just get this court fatigue where if you're lucky in a mediation, which I was, they've come to years and years and years of all of this conflict, and they've both decided, and I think the mother would have decided this ages ago, but they've both decided that they've had enough and they want to settle. So that's something interesting too, because sometimes when you read theory about mediation, the theory is if you don't get people early enough, the conflict will be too high and it won't be that easy to mediate. Well, that can be the case, but on the other hand, sometimes they can then come out the other end and they've been through all of this battle, and you get them, because at the moment, the Family Law Practitioners Association have a pro bono mediation scheme at this point, which only some of the judges are participating in. But it's quite surprising that at this stage, because it's taken maybe it's taken a year and a half to get there, that sometimes the people at that stage where they're supposed to be sitting down for a hearing, they're then told it'll take 1.5 years for their hearing, and they just go, we're tired of this, we really want to settle, and it's actually quite mediatable. So that's quite interesting. Okay, so the process that we're going to be learning about in this course is called the facilitative mediation process, and these are the steps in the process that you'll be learning about. So the first step being the intake and screening. So assessing what the issues are, seeing where the parties are at, and then screening for suitability, whether the people can participate, and also whether it's the sorts of issues there are appropriate. Then coming to the actual day of the mediation, the mediator, we as our family dispute resolution practitioners making our opening statements, and then following a set process, which is a step-by-step structured process where we get each party to make an opening statement, then we get them to agree on a structure for the mediation and what issues they're wanting to discuss. Then we, and depending on what the issues are, but often one by one, get them talking about those issues and exploring them. Once they've had some discussion, start to get them to thinking about options, and then getting more down into a negotiation and possibly agreement on some of all of the issues. I guess something we can't guarantee at a mediation is the agreement. And depending on the process, I think in your process, you can have several mediations with people. And that's a good process in that sometimes people do need a couple of meetings to be able to sort of reach, it can be more helpful to be able to reach agreement if you just don't have a one-off sort of meeting, which a legal aid mediation often is, where people get told, well, this is your one chance, you've got 4 hours. Sometimes we do get agreements, and probably the majority of the time we do get agreements in legal aid mediations, but it's a lot more pressure on people than if they get the chance to come back and go away, think about things, maybe gather some more information when they need it, and come back. And then the very last stage, if they have reached agreement on some or all things, is helping them draft up the agreement. So any questions about the process?
When you do with them for legal aid mediations, do you still do the intakes and screenings like before the day of the mediation?
For that particular process, the mediator doesn't do the intake and screening, an administrative person does. So it's
But it's before the day. So
yes,
they're
it
not
is
like
before the
open.
day. Yes.
So when you say the mediator's opening statement, what's that around?
It depends.
Introducing yourself, the service, what is it about?
Yeah, well, say it depends on your process. If you have spoken to your people in intake,
Mm-hmm.
you've already introduced yourself and you've given them a whole lot of information. But then on the actual day, you might want to remind them of some of that information, and just sort of go through again what the process is, what the time frame for today is, that type of thing. So it's sort of like an introductory, and also about sort of, you know, just on the day of the mediation, breaking the ice, getting them a bit more relaxed. Normally people are really stressed when they come to mediation, and yours will be on the telephone, won't they, a lot of the time? So on the telephone that's a bit different, but they're still got the same issues. So reminding them of a bit of the information and what the process is, setting out some guidelines for behaviour, maybe reminding them again about confidentiality, that sort of thing. Also, say if you're going to be on the telephone and you'll have time together on the phone, time separately. So all that stuff about the process.
And I guess the parties' opening statements, is there a guideline for that, or is it just...
Yes, no, it again depends on sort of your time frame, but often at the beginning you want to get the issues. So working out what issues they're wanting to discuss, and then getting some more information about that. Okay, well we might, and I can't remember in my schedule when I was having morning tea.
Yeah, 10:30.
Oh, so it's morning tea time.
So